Okay, before we get started, we are going to have one last drawing by Happy State Bank, and you have to be present to win. So if you're still outside, come back inside, and we're gonna draw 2 names. Go ahead.
I guess I'll keep to the theme of the last 2 speakers. I'll say that I am like the cow walking through the tall grass. I'm utterly tickled to be here. So I'm Brian Limmer. I'm with Happy State Bank and Trust Company. We're certainly honored to be here and have the opportunity to sponsor the event, and we always look forward to that every year. And we have a couple of Happy State Bank Texas scratch pads, which are basically $50 in cash. They look like little notepads, but they're full of $5 bills. So we'll draw 2 names. And the pool has significantly been reduced. That's one we lost to. It's H. Where's he? I don't. Okay, he's not here.
No, he's not.
All right, let's go. Do it some more. We'll do it some more here. Myrtle McDonald. Where's Myrtle? Did she leave? Is she outside? No. Amy Jones. No? Okay. Let's do a little peeking early. Here we go. Try it again. Sorry. Kathy Peak. All right, Kathy, let's get another one. I'll bring it up there in a minute. Yeah. Vic. Where's Vic? There he is, Vic Wahira. Yeah, we go. All right, thank y'all very much.
Thank you. Our next speaker is Professor William P. LaPiana. Professor LaPiana is the Rita and Joseph Solomon Professor of Wills, Trust, and Estates, as well as the Director of Estate Planning Studies in the Graduate Tax Program at New York Law School. Professor LaPiana holds both a PhD in history and a JD from Harvard, where he also received his BA and an MA, and after graduating from Harvard Law School, in 1978, Professor LaPiana spent 4 years as an associate at Davis Polk & Wardwell in New York. Professor LaPiana is the author of several articles on estate planning, numerous articles in American legal history, and has authored several books. He has also been active with the Trust and Estates sections of both the New York State and the American Bar Associations. In 1992, he was elected as an academic fellow of the American College of Trust and Estate Council and is a member of the board of directors of the ACTEC Foundation. Professor LaPiana's presentation today will be on same-sex couples planning updates, and if you will please help join me and welcome Professor LaPiana to the stage.
Good afternoon, everyone. It's always a wonderful pleasure to be here. This is such a wonderfully run event. I have been speaking on this topic to you over the years in which it has changed, of course, greatly. And in one sense, all that's left to talk about are cleaning up some of the details, I guess. And there are going to really be 4 things in the short time we have today. First, where we are right now and where we might be going. Some professional responsibility issues that are perhaps not quite as well focused as they might be. At least a lot of people haven't thought about them, I think, a lot. A little bit more on retroactivity of Obergefell and actually of Windsor in the tax area, which has its own interesting little details and is based on a newly released IRS notice. And then some of the collateral effects of the legalization of same-sex marriage. Interesting things are happening with the law of parentage directly related to same-sex marriage, and a little bit on what it's meant for common law marriage. And a couple of other little details at the end, some remarkable and perhaps surprising stuff. Now, as we know, full recognition of same-sex marriage is the norm in the United States since Obergefell. That recognition and the federal recognition undoing the so-called Defense of Marriage Act rests on Supreme Court cases, both of them decided by 5-4. Now, will that change as the personnel of the court change, as it's quite likely to do over the next few years? The answer to that is who knows. I think that the determining factor will be the degree to which the court is willing to overturn very recently decided major precedent. And that may very well come down to whether or not Chief Justice Roberts is willing to do that. So we shall see. What is really unknown, though, is what might happen with what could be quite a bit of litigation over the free exercise clause of the First Amendment. As we have seen, there have been certainly state cases about the refusal of businesses to deal with same-sex marriages and the desire on the part of some businesses, individuals, and organizations not to have to recognize same-sex marriages. All that non-recognition based on appeals to religious belief. So clearly this sets up a very complex constitutional issue, which of course will play itself out over the next few years. Again, exactly how, very difficult to know, and we will just have to wait and see. So that's what may or may not be coming. What I want to turn to now is something that we perhaps haven't talked about enough. And that is the professional responsibility rules that govern in dealing with same-sex couples. And in one sense, there's nothing to talk about because married means married. Planning for married couples is planning for married couples in both a tax and a property law sense. And how one deals with them in the framework of professional responsibility is the same, whether it's a different sex or same-sex married couple. But this gives me an excuse to highlight for you, some changes that may be happening in the way we address the ethical issues that surround helping married couples planning for their wealth after death. Now, what I'm going to tell you is based largely on the American College Trust and Estates Council's commentaries on the model rules of professional responsibility or professional conduct. The commentaries are now in their 5th edition. They are a series of comments to the model rules written from the point of view of the problems that face trust and estates lawyers. A point of view dealing with the rules that actually is lacking in an awful lot of the material that's out there. Now, it's the product of a small group of practitioners and academics. The comments themselves, of course, have no legal force whatsoever, but they are very well done and thoughtful, and the commentaries collect, it's probably the single most extensive collection of cases, rulings, state bar ethics opinions, both formal and informal, on applying the rules of professional responsibility to T&E practice that you will find anywhere. And it is kept up to date on a very current basis. So if you go to the organization's website, actec.org, on the public part of the website, you can order a copy of the commentaries, you can download a PDF of the entire document, and you can have access to the updates on the annotations that are done. So the two rules, of course, that are most implicated are 1.6 on confidentiality and 1.7 on conflicts of interests as applied to current clients. Now, one of the few things we can claim that give us some claim to moral responsibility, I suppose, is we keep people's secrets. I have secrets from that short time I practiced almost 40 years ago now that I will still keep, and of course, it's a cliche, but it's true. We take them to our graves with us. That works just fine when you're representing one person in some kind of transaction or litigation or dispute. You can keep their secrets for them within very broad parameters. Obviously, if they tell you they're about to commit massive bodily injury on someone, you have some duty to report that. But generally speaking, we keep secrets. Now, this becomes a little problematic when you're representing more than one person. I'm going to put entities aside for a minute because that's really not our emphasis at the moment. And there have always been two ways to deal with representing more than one person, or in the married couple case, the two spouses. One is separate representation. I am the lawyer for each of you, and theoretically, I will keep your secrets from each other. The other is joint representation, in which I am, it's a little like the concept of joint tenants with rider survivorship, right? You're sort of one thing. Maybe tenants by the entirety is better. You're just one thing, and when one of you goes away, the thing is still there, just one of you owns the whole thing. But I represent you jointly, which means that whatever one of you tells me, I will tell the other. It has long been the position of a lot of experts, people who think about this, and of the ACTEC commentaries, that there was a choice to be made between those two methods or styles of representation, and which one was decided on was fine as long as the clients gave informed consent to it. What that generally meant was, here's the engagement letter, sign this copy and return it to me to indicate that you understand what we're doing here. The idea of separate representation was never, in any sense, a majority opinion. And the interesting thing about the latest edition of the commentaries is that under the annotations, under the comments, I should say, for Rule 1.7 on current conflicts of interest, the commentators state quite clearly that representing a married couple in their estate planning as separate clients, quote, is generally inconsistent with the duty of loyalty to each, and that therefore the only way to really do this is to secure their consent to joint representation. Now, the idea behind joint representation, of course, is that the clients understand that neither of them should tell you anything that they don't want the other to know. Because you've told them, what one of you tells me, I will tell the other. The problem with that, of course, is people just can't shut up. They will blurt out things to you that you absolutely don't want to know. And in that situation, generally, what is counseled, and the commentaries follow this approach, is that first one must try to convince the client who's revealed this to you to reveal it to the other person. This may be difficult when they're spouses. Then you might have to withdraw from representing one or both. Now, that's not going to keep anything secret, because people are going to want to know, why are you doing this to us? But at any rate, that's the idea. The advocates of separate representation, the most prominent of whom, in fact, was Professor Jeff Pennell at Emory, always said separate representation was fine because there were secrets that were absolutely not important. For instance, one of the spouses tells you, I had a non-marital child many, many years ago who was adopted, whom I surrendered for adoption, was adopted by strangers. No relationship, family relationship to that person at all. Their existence, whether they're still alive or not, has no effect on the distribution of my property or any property I might get from my spouse. Just not important. The example used in the commentaries is a long ago marital infidelity that's long ended and no longer significant. Interestingly enough, in now promoting joint representation as the only way to go, the comments in the commentaries say, but joint representation does not mean you have to reveal to the other client trivial things you learn. And what example do they use for trivial? The long ago marital infidelity. And I suppose they could have also used the long ago non-marital child. So what we've got is, in this very widely respected and widely quoted commentary, an idea that separate representation is no longer any good, but joint representation isn't so different from separate representation, at least when it comes to those trivial things that one spouse need not know about the other. This is where I announce somewhat smugly, I'm so grateful I don't actively practice anymore. What in the world is trivial in considering a married couple? I don't know. So the big hope for joint representation is that neither party will reveal to you anything that they truly want to be kept secret. Now, as I say, those are interesting changes going on, and it's something to think about. But I do think that the nationalization of same-sex marriage does raise a very interesting issue of loyalty to the client and conflicts of interest, which might be very particularly appropriate here in Texas or in any state that has community property. Let me give you my hypothetical. A same-sex couple who are Texans, domiciled in Texas, before Obergefell and after Massachusetts starts to allow same-sex couples to marry, go to a state where they can marry, and they marry and return home to Texas. When my spouse and I were getting our marriage license, we met a couple from Texas, two guys from Texas who were doing exactly that. They return home from Texas and they continue to live together until the date of Obergefell. Now, if Obergefell is retroactive, and Professor Tritt and I, as I'll say in a minute, a little more detail, truly believe it is, this same-sex couple has been married since they got married. And during all that time, they've been accumulating community property. They may desire, now that it's unequivocal that their marriage is recognized in Texas, that a lot of what would be separate property, even if you start the marriage at date X, what would have been separate property, should be community property. Because after all, they've been together for a long time. Their marriage is what I'd like to call a ratification marriage. After years of being together as a couple, they can finally get married. And you know, who doesn't want that basis step up when the first spouse dies? So they would like to transmute their separate property into community property. So you're doing their estate planning, putting their documents together, and then they announce, you know, one of them says, I have all this separate property, whenever you decide our marriage actually started for Texas law. And the other says, I have kind of a little bit of separate property, but we just want it all to be community. Now, we would never represent both sides of a prenuptial agreement, right? Would never represent both sides of a postnuptial agreement. Can you really represent both sides of an agreement to transmute separate into community property when one of the spouses now is actually making an enormous transfer to the other if the more affluent spouse dies first? Really represent them both? I don't know. Now, I'm sure that you've got a lot of experience in doing that. Surely couples must come together and want to commute things into community property either before or after they marry. But it's something to keep in mind that's raised this particular ethical issue, I think, when it comes to dealing with same-sex couples. Now, those are interesting issues in and of themselves, and we certainly will see more development there. The third issue I wanted to talk about is our old buddy retroactivity. And this actually is page 22 of the outline if you're following along. Last year I spoke a good deal about this, and Professor Tritt and I have spoken about it together at one CLE presentation or another, and now he has done a wonderful article which is cited in the outline in Wisconsin Law Review, which summarizes just about everything we have talked about. I certainly agree with the views he expresses in that article. And those views basically are Obergefell is indeed retroactive, and that one is married from the date one was validly married, even if your state only recognized that marriage from the date of Obergefell. Now, this was significant for so many things. Again, think about our Texas couple married out of state, coming back to Texas, and sometime before Obergefell, one of the spouses who owns the family home in his or her name alone decides to sell it. They're the only name on the deed going in. They're the only name on the deed going out. Is there something wrong with the buyer's title? Because this turns out to have been now community property. Well, I think the conclusion, and Lee Ford agrees, I'm sure, I know he does, is that no, because if you look at the cases in analogous situations, as long as you've sold to a bona fide purchaser, the bona fide purchaser's title is just fine. The proceeds, of course, are probably community property, but you folks trace stuff all the time, so that's nothing new. The one area in which we thought retroactivity was not very important was in tax, because certainly after Windsor, the federal government, the Treasury issued regulations and notices that said, okay, we recognize same-sex marriages as long as they're validly performed, no matter where the parties live. And if that period for adjustment, the usual 3-year period in which you can file an amended return to get that refund that you're suddenly entitled to, has not passed, we encourage you to do that if it's to your advantage. You were married, so now you can file jointly. So if going back 3 years, filing jointly for one of those years gives you a lower overall tax bill, go ahead and do it. But if the 3 years are up, sorry, it's all over, nothing you can do. Unless you filed some kind of protective election, which would be somewhat unusual, I think. But that still left one odd little problem out there. Here's the example. The couple is absolutely validly married, but DOMA is in force. It's before Windsor. And one of the spouses makes a gift to the other, outright gift, in a value greater than the present interest exclusion. And being absolutely forthright about this, they file a Form 709, and which shows that there is no tax due because there's more than enough unified credit to offset the gift tax. But they have used up unified credit. Had the federal government recognized their marriage, they would have had a marital deduction for an outright transfer to the other spouse. Now, Windsor comes along more than 3 years after that gift was made, and here they've paid, they haven't paid gift tax, they're not out of pocket, but they've used up unified credit. In Notice 2017-15, which has just come from Treasury, the service says that you can recoup that unified credit you would not have to have used up if we, the feds, had recognized your marriage. What that means is the next time you file a 709, you put over it, file in accord with notice, this is filed in accord with Notice 2017-15, and you can recover the unified credit you used up in that years ago transfer. Now, you're not going to get a refund if the period for assessment has passed, but you'll get the unified credit back. No need to file a return specifically for that purpose. Just the next time you file a 709 or when the transferor dies, their 706 will show recouping the unified credit. And there's going to be a worksheet to show you how to do it that will be out soon. Same thing for generation skipping transfer tax exclusion. Now, remember, if you're not related to someone or you're not married to someone who's related to the donee, generation assignment for GST purposes is based on relative ages. So I have an absolute real-life, very personal example. My spouse has a niece and a nephew. I am old enough and they are young enough that as to me, they are skip persons. They're 2 generations younger than I am based on relative ages. Once I marry their uncle, they're not skip persons because they're 1 generation down from him, so they're 1 generation down from me. Had I made a greater than the applicable exclusion amount gift to Sam and Sophia, that would have been a direct skip. And the only way to avoid paying generation skipping transfer tax would be to allocate some of my GST exclusion to that gift. Well, just like now that the marriage is recognized, they're not skip people anymore, and there is no GST on a gift to them, outright gift, so I could recoup my GST exclusion that I used up. Again, on the next 709 I file, or the 706 if it has to do, it's going to be implicated when I die. I'm allocating GST exclusion then. This ruling, let me step back for 1 minute. Number 1, if to get that marital deduction, you would have had to have made a Q-tip election because you created a trust for your spouse that is a Q-tip trust, but you couldn't elect because the marriage wasn't recognized, you've got to go for 9100 relief. You have to ask the service to allow you to make a late-in-time Q-tip election. The implication from the language of the ruling is that will be allowed. But you have to ask for it. The other thing you have to remember is this applies only to married couples. as has been the pattern ever since Windsor was decided, as far as the federal government is concerned, the various marriage equivalents, civil unions, registered domestic partnerships are not marriage. And if you are in a civil union with someone and make an outright gift to them, pre-Windsor, post-Windsor, doesn't matter, no marital deduction. The only place in the federal framework where that is not the case is Social Security, where for Social Security purposes, non-marital legal relationships that give the inheritance rights of marriage are recognized as equivalent to marriage. But that's the only place in the federal system. Now, what this means is, as far as Treasury is concerned, Windsor is retroactive, because otherwise, how can you possibly get that applicable exclusion amount back? So, at least for now, that's Treasury's position. And it comes the closest statement we have, I think, from the federal government about the retroactivity of these important cases. Now, if we go back to the beginning of the outline, starting on page 3, I'm going to move a little further away from directly talking about same-sex marriage to the effect the recognition of same-sex marriage is having on the law of parentage. This is actually, I think, going to be ever more important very quickly. Obviously, so much planning for the transmission of wealth, and transmission of wealth on death without planning, i.e. through intestacy, depends completely on concepts of family. And how do you get family? You either marry someone, or you have children, or it's the equivalent of having children. You adopt them. What has happened is particularly the ability of two women to marry has begun to make the courts think about things that obviously before the ability to marry simply were not possible. For instance, two women are married. One of them conceives through artificial insemination and gives birth. Is that child the child of her spouse without her spouse having to adopt that child? Well, there are two general legal rules applicable here. One is an ancient presumption that a child born to a married woman is the child of her husband, and the other are statutes that exist in almost all the states that say if a married woman conceives through artificial insemination, often performed by a medical professional, with the consent of her husband, the resulting child is her child and the husband's child, and the birth certificate should reflect that. There is no need for adoption or any other legal event to make that happen. So does that apply to two women who are married? The earliest answers, the very earliest cases said yes. One of the strangest ones from New York, which is mentioned in the outline, matter of Seb CM on page 4, took that to its logical extreme. Married same-sex couple, one of the women conceived through artificial insemination, bore, in fact, 2 children over time, and her spouse wanted to adopt them because at that time their marriage was not recognized throughout the United States. They worried what happens when we travel to a state where our marriage is not recognized because the non-birth mother's parentage rights arise solely out of the marriage. And the judge said, you're not going to be able to adopt because it's absolutely superfluous. You're their parent to begin with. No adoption. Which is absolutely, perfectly, probably correct, but of little help to the couple. Interestingly enough, very late last year in the very same county in New York, the family court allowed 5 couples in that situation to adopt. That is, the non-birth mother adopting the child her spouse had born, very simply for the reason that they may travel somewhere where the marriage is not recognized or where it might be difficult for people to understand that it's recognized. And these adoption papers will be necessary to show that the non-birth mother is indeed that child's parent. Now, there's been a steady stream of litigation where married female couples in this very situation, have had to fight to get the state to put the non-birth mother's name on the birth certificate. These are discussed starting on page 5. One of the earliest ones was in Utah, where the federal district court issued an injunction that told the Department of Public Health, you must put the other spouse's name on the birth certificate as parent. A Wisconsin Intermediate Appellate Court refused to, but then Wisconsin administratively changed its policies beginning on May 2, 2016 to provide for what they called a birth certificate worksheet that allowed the other spouse's name to go on the birth certificate as parent, whether the same sex or different sex from the birth mother. And then the federal district court ordered Wisconsin to do that for the period before May 2nd, 2016, to administer its artificial insemination statute in a gender-neutral manner. Same result in Indiana in the federal court, in Florida in the federal court, in Nebraska in the federal court. And in a divorce proceeding in Arizona, the Intermediate Arizona Appellate Court said, again, in this situation where married same-sex couple, one of the women gives birth through artificial insemination while they are married, the court says this will proceed as a divorce where there are children of the marriage, principally because you must administer or apply the artificial insemination statute in a gender-blind manner after Obergefell. And indeed, in that case, too, the court noted, the birth mother is stopped from denying her spouse's parentage of this children, given the way they had lived together during the time when they did, before they split up. The only case that has not gone this way is a case in the Supreme Court of Arkansas. It's on page 7, Smith v. Pavan, in which a bitterly divided Supreme Court said that the parentage statute and the artificial insemination statute referred to wives and husbands. And the only way to change that would be to have the legislature change that. 3 justices dissented, although on slightly different grounds. They all believed, said the court should have held, that Obergefell requires the artificial insemination statute to be applied in a gender-neutral manner. Now, this might not do married same-sex couples much good, because they're going to have to have children, or the biological children of one of them, at least, or to have children other than by adoption, is going to be through gestational surrogacy. And the statutes that govern gestational surrogacy actually are the ones that are going to be relevant here. We're not going to talk about that now. There have not been any cases yet, but there indeed probably will be. The right answer here, what is the right answer? Well, a lot depends on how you think why the artificial insemination statutes and the parentage presumption exist. If they come solely through the status of being married, then it makes sense to apply it to same-sex couples, at least to female same-sex married couples. If they come from biology, we've got a problem. The artificial insemination statute, however, I think is easy. The artificial insemination statute applies because the spouse of the birth mother, we know, is not genetically the parent of that child. And yet the law will treat that spouse as the parent so long as they consent to what the birth mother did. That applies as equally to different sex couples as to same-sex couples. And in that sense, and I think the courts agree on the whole, that's the right reading of that. The other thing that's happened involves equitable parentage. This is the idea that one can become a parent without adoption simply by acting as a parent. The rise of cases involving female same-sex couples, one of whom has born a child, and then with her spouse raises the children together, and then the couple breaks up, has presented this question and is presenting it more and more to the courts. One of the earliest cases in Michigan, you see on page 9, the Stankovich v. Milliron case. There, the couple was married. They'd left Michigan to marry, came home. Michigan didn't recognize their marriage. Michigan applies the equitable parentage doctrine only to married couples. And the state Supreme Court said, look, we will apply it here because you were validly married. We now recognize your marriage. whether we should have recognized it or through some idea of retroactivity, but you, the non-birth mother, can show that you should be treated, at least for purposes of visitation and custody and support, as a parent of this child. Although the Michigan Intermediate Appellate Court would not apply the equitable parentage idea to a same-sex couple who broke up without ever marrying, even though they made the argument that we would have married had the law allowed us to, although it didn't. Oklahoma took the other position, that's the Rami case you see on page 9, and claims by women's same-sex spouses to equitable parentage of the children to whom their spouses gave birth has led two state Supreme Courts in New York and in Maryland to recognize equitable parentage for the first time. New York was adamant for years the only way to become a parent was through birth or adoption, and finally overruled that just within the last few months when faced with this paradigmatic situation. The female married couple, one of whom gives birth through artificial insemination. The other spouse should have the rights of a parent, at least to visitation and custody. Now, there is a new revised Uniform Parentage Act being drafted by the Uniform Law Commission. It recognizes, in the drafts so far, de facto parentage, which is the same idea, but not really. Because, again, equitable parentage in states like New York, Maryland, Michigan, equitable parentage means for purposes of custody, visitation, and support, you are a parent. De facto parentage, as the revised Parentage Act apparently is going to deal with it, makes the de facto parent the parent for all purposes, including property law purposes. So not only does the child have inheritance rights, but presumably the relatives of the de facto parent have a new relative, a niece, a nephew, a grandchild. So that if a grandparent of the de facto parent leaves a will that says, I give $100,000 to my grandchildren, at least under this statute, that will include the de facto child of their child. Now, it's interesting, this is one of these examples of how the American legal profession, at least in academia, sometimes doesn't talk to itself very well. Most of the drafting of this is in the hands of people who are family law experts. The ABA advisor to the committee, Mary Lou Fellows, who is an emeritus professor from the University of Minnesota and one of the most distinguished T&E academics of, at least I have to now say, my generation. She is the one voice on the committee for trying to understand what this means for property law purposes. So what will happen with this statute once the Uniform Law Commission promulgates it, we will see. But this growth of the idea of becoming a parent, acting like a parent, is going to have property law ramifications that I think we don't even understand yet. So that will be something to look for. Now, I promised you a few little bits and miscellaneous pieces in just of the time I have left. And the first is something I know that's very important here in Texas, and that's common law marriage. Basically, the question is, and this is towards the very end of the outline now, on page 43. The question is, okay, you live together as a couple in some instances for decades. And then one of you died right before same-sex marriage was possible. If the jurisdiction recognizes non-ceremonial marriage, can we treat the two of you as married? We have two cases from Pennsylvania that say yes. Couples that lived together before Pennsylvania undid non-ceremonial marriage by legislation in 2006. And in both cases, the courts have said, yes, this couple was married. They held themselves out, not in the traditional formula, of course, as husband and wife, but as spouses. Now, these are trial court cases. They've never been appealed. The result of them was pension rights for the survivor. They are very appealing cases. So those seem to be very easily decided. I know there's a case in Texas now where the opposite result was the result. But in part, that rests, as I understand it, in the fact that non-ceremonial marriage in this state actually rests on a statute. And if a statute says holding yourselves out as husband and wife, you have to wonder, or as a married couple, can that happen? Why marriage wasn't possible? Interesting. There is an Illinois state Supreme Court case just decided in the last couple of months, very end of 2016, Blumenthal v. Brewer, on page 44. There the court held that common law claims asserted by one partner against the other on dissolution of the relationship, again a same-sex couple who could not marry at the time the relationship went on, were barred because there is precedent in Illinois barring what they call private creation of marriage-like rights and duties in light of the fact that their legislature abolished non-ceremonial marriage. So presumably once having abolished it, there's no way to recreate it, even if you couldn't marry. And two justices dissented on exactly that ground, that the couple could not have married during the time they were together. And it's more equitable to treat them as married. And then finally, another sort of two more little things. One on the bottom of 44, in matter of Munson and Beal, the New Hampshire Supreme Court was faced by a divorce proceeding between a female same-sex married couple, in which one of the partners contended you should treat our relationship for purposes of finding marital property for equitable distribution from when we were cohabiting and could not marry. And the court said, no, we're not going to do that. What we are going to do is say, when it comes to gauging the length of a marriage in dissolution proceedings, we now direct all the courts of New Hampshire to take into account any period of cohabitation that preceded the ceremonial marriage, which I think is an interesting sort of collateral effect of recognizing same-sex marriage. It applies to all cohabiting couples now. And the other is we now have two cases, kind of something that people had hypothesized would happen, and lo and behold, it has. There have been cases, who knows exactly how many, of one partner in a same-sex relationship adopting the other in states where that was possible in order to create a family relationship to provide the property law protection one wants. It might be simple as, if you are now my child, when I die, you are my sole heir, and my family members cannot attack my will because they have no standing. Whether or not that also makes you a child for purposes of other family members' wills and trusts, another issue entirely. But that's often why it was done, just to protect our relationship. Well, sure enough, we could have predicted this would happen. Once same-sex marriage becomes possible, the couple would like to marry, except there's one slight problem. It would be incest. And we now have two cases, and they're in the very last page of the outline on page 45, one in Pennsylvania and one in Delaware, annulling the adoption of one partner by the other in order to allow them to marry. And principally because the adoption was there to create a family relationship, now there is a more straightforward and indeed appropriate way to do it. And the Delaware case in particular is a very interesting essay on the Delaware law of when adoptions can actually be annulled. So while the same-sex marriage is established, it is possible, as in so many things in the way our legal culture works, its effects keep rippling out and are beginning to affect and maybe accelerate legal change that might have happened anyway, but now it provides a context. Whether it's for treating cohabitants as actually married when their subsequent marriage dissolves, whether it's beginning to transform the law of parentage to take into account de facto and equitable parental rights. Not so much that same-sex marriage is causing these changes in some sense, but it's providing the context in which now these issues are being played out, which would not have been there had not Obergefell happened. Thank you for your attention. And whether or not there'll be more to talk about in years to come, who knows, but I have a sneaking suspicion there will be. Thank you.
Thank you, Professor LaPiana. Our final speaker for the day will be Derek Mergele-Rust. He is a 3L student here at Tech Law and also the executive comment editor of the EPJ. He is from the Austin area and is a graduate of Texas State University, where he received a Bachelor's of Science in Geography with an emphasis in urban planning. And he also has a Bachelor's of Public Administration. Derek will be presenting his article published in Volume 8, Book 2, titled Splitting the Baby, The Implications of Classifying Pre-Embryos as Community Property in Divorce Proceedings and Its Impacts on Gestational Surrogacy Agreements. Please help me welcome to the stage Derek Mergele.
Can everyone hear me okay? Some of the EPJ members are coming around as a thank you for staying all the way through the end of the day. They have some chocolate-covered espresso beans. Law students thrive on caffeine, so hopefully this will help get you through the rest of the presentation and on to dinner. I actually am very excited to follow Professor LaPiana and get to expand a little bit on some of the concepts that he was hinting at. And so I actually want to talk about in vitro fertilization and artificial reproductive technology. And so there are a couple cases that are kind of at the heart of this situation, both involving heterosexual couples, but I think a lot of the principles, as Professor LaPiana alluded to, are applicable to same-sex couples as well. But before we get into those cases, there's a couple things I want to define. First, if you in the title of my article, I mentioned pre-embryos, and pre-embryos are organisms that are exist in the 14 days prior to the attachment of a uterine wall. So a lot of times where this comes into play is if you have fertilized eggs that are still outside of a human body, female human body, in cryogenic storage. That's really what we're talking about here before implantation. As a point of reference, the first baby that was born as a result of in vitro fertilization was 1978, and since that time, over 45,000 children have been born using IVF. So in Finley v. Lee, we have Stephen Finley and Dr. Mimi Lee, who both live in San Francisco, California. Mr. Finley actually, though, works in New York City, and they have a bi-coastal relationship. Dr. Lee is a doctor in the University of California medical system. They were married, and sometime during their marriage, she was diagnosed with cancer. The case is not very specific as to what kind of cancer she had, but they were concerned that the radiation treatment would affect her ability to conceive naturally. And there was a conversation about whether or not they should just harvest her eggs and freeze them, or actually do an insemination and freeze the pre-embryos. They elected to freeze the pre-embryos, and then she went on to do her cancer treatment. In that process, they signed what is commonly called an IVF agreement. And IVF agreements are kind of the contractual obligations, as it were, about what to do with the embryos, what to expect, and what the responsibilities are between the hospital and the progenitors. And progenitor is a word that simply means the intended parents. However, in 2013, Mr. Finley filed for divorce, and there were those pre-embryos in storage, and they were trying to figure out what to do. IVF agreements often specify what the hospital system is supposed to do in the eventuality that certain situations happen, including death of one of the progenitors or dissolution of the marriage. In this case, what it said was that the embryos should be destroyed. Dr. Lee, having been through her cancer treatments, did not want the embryos destroyed. And her lawyer filed a couple what I would consider creative arguments for why this IVF agreement should not be legally binding. One of which was she said this is merely an agreement between Finley and Lee and had nothing to do with the University of California, San Francisco medical system. And that the agreement was merely a medical directive and not a legally binding contract. UCSF was also a third party in this case, and they asked the court to find that the agreement was binding after a determination that the embryos are actually property, a special kind of property, and not life, which is an argument that Nick Loeb will make in the case of Loeb versus Vergara. And in fact, in Loeb versus Vergara, we have Nick Loeb in Florida and we have Sofia Vergara in California. And they have 2 embryos in storage. And their IVF agreement is not the standard one that's used in San Francisco. They're in LA. And it just says that nothing's going to happen without the consent of both parties. Mr. Loeb basically tried to say that IVF agreement cannot be legally binding because it does not meet California statute, and that the embryos are life and not property. So what kind of property interest do we have? Of course, if we have property, then there's, okay, who has what amount of interest? If we're going to talk about divorce, when we talk about community property, well, does each person have an interest in a pre-embryo? And just humor me for a moment, and if we talk about women's anatomy, women are born with all the eggs that they're going to have in their life, and men continue to reproduce sperm throughout their life. So does that mean an egg is separate property and sperm is community property? Yes, and so what you end up having is at the end, when you have an embryo, so women are likely, if we went through this tracing exercise, women are likely to have a 75% interest in an embryo, and men are likely to have a 25% interest. However, if you have a donated egg, then we're back to separate property for both the sperm and the donated egg. Monetary valuation, maybe a court, when we're doing an equitable division of the assets, would include maybe the cost of the IVF treatment as the cost, maybe not. Or there's an assignment of the eggs without any monetary valuation considerations whatsoever. But in deciding whether or not these agreements are binding, there's basically 3 approaches that the court likes to take. One is the contractual approach, basically that these IVF agreements are contracts and they will be held to be enforceable. There's also a contemporaneous mutual consent approach, and basically meaning that both parties have to agree at the same time on what they want to do in order for something to happen, and that the IVF agreements are not legally binding. The Pennsylvania Supreme Court has kindly reminded people that if they could agree at the same time, they wouldn't be in court. So that particular approach does not have a lot of weight. And finally, the balancing approach is a balancing of the interests of the 2 parties. Specifically, what we're looking at are constitutional interests. Coming down from the sexual reproduction freedom cases, Griswold v. Connecticut, Roe versus Wade, a person has a right to procreate. But the other spouse who doesn't want the embryos to turn into human beings also have a right not to procreate. And so the court has to weigh those interests. So where does that leave us? The Tennessee Supreme Court in 1992 is the seminal case, Davis versus Davis, and they are kind of lay out what the best approach is. We should have the wishes of the progenitors control. If they're ambiguous, prior agreements should control. If there's no prior agreements, then we have to weigh the interests of the parties, again, going back to those constitutional arguments. Usually the only way that a progenitor is going to get the embryos where there's not agreement is if they are physically unable to have children any other way. So what happens if a court awards an embryo to someone who's biologically not able to have children? When we get into gestational surrogacy, which we were just talking about a moment ago, gestational surrogacy is merely the process of an embryo being implanted into a host that is not the biological parent. And there's a lot of different ideas about whether or not this is a good idea or a bad idea. And we have a couple different Uniform Parentage Acts, the 1978 law, the 2002 update. And if you were keeping track, IVF became possible in 1978. And so our Uniform Parentage Act from 1973 is not necessarily relevant or applicable. But in Texas, we do have a combination of the 1973 and 2002 acts, and that's Texas Family Code section 160.754. And the agreement must be written. The gestational agreement must be between the mother and her husband if she's married, and the intended parents. The intended parents must be married, which for same-sex couples wasn't possible until Obergefell. And the gestational agreement must be validated by the court. A non-validated gestational surrogacy agreement will not be enforceable. That could mean something to the effect of that you have a woman who brings a child to term, she's not the intended parent, the agreement's not validated, and all of a sudden this woman who is carrying this child may have all the parental rights of a surrogate child. So the key takeaways here in this particular presentation, especially for estate planners, these IVF agreements may control over any sort of will. That's never been litigated, so there's a possibility that if a will wants something else to happen with pre-embryos, that may be an interesting litigation topic. IVF agreements should specify what to do in the disposition of divorce or in the in the case of death of one of the progenitors. And if you do have somebody with a surrogacy agreement, make sure that it's validated by a court. So thank you very much for your time. Appreciate it.
Hello, can you hear me? Okay. I just wanted, before we wrap up, to give a special thank you again to our sponsors, to Texas Tech Law, to having these great facilities for us to use, to Professor Beyer as our faculty advisor for the EPJ, all our EPJ members who put in a great ton of work, especially Michael Otten. He's there in the back. Can we give him a round of applause real quick? He's done a great job. And this concludes our presentation for today. This West Texas legal community is phenomenal, and we are so glad and thankful to have your support, and we hope to see you again next year. Thank you so much. There's still snacks and refreshments in the back, so please help yourself. Thank you again for everything, and we'll see you again next year.